Recording.
Well, good morning and welcome to Forums That Matter, a community service to the Unitarian Universalist congregation. I'm Ken Fries and I'm a member of the Forum Committee and I'm coordinator for today's discussion, which is both remote and in person. Our topic today is President or Monarch and unpacking the Supreme Court immunity ruling. We'll have a Q&A from 9:30 till 10 with Nancy and Gary. Will provide and collect cards, index cards for our in-person audience. And we asked our visual audience to use the Q&A box on their computer. Virtual viewers can also turn on caption or turn it off for their computer. In a fellowship hall, please make sure your phones are shut off or in airplane mode. Our recording today will be posted on our website at uucleveland.org. Now, it's my pleasure to introduce our speaker, Jonathan Entin, is Professor Emeritus of Law at Case Western Reserve, held an appointment in political science and served as Associate Dean for Academic Affairs at the Law School. He has taught and written on the presidency, presidential power, civil rights, constitutional law, and administrative law. Among his many awards, he was chosen Teacher of the Year by Step 5 graduating classes, and he was also Administrator of the Year. The Federal Bar Association awarded him for excellence in civics education. Many of his former students endowed a fund in his honor to benefit the Case Western Reserve Law Review. Now, Professor Entin is the graduate of Brown University with a JD from Northwestern. Now, this is interesting. All young lawyers have to clerk. He clerked for Ruth Bader Ginsburg. And another showstopper, when he was working for a private law firm in DC, he helped exonerate an innocent man who was scheduled to be executed in 2 hours after he was exonerated. So with that said, our guest.
Thank you, Ken. Just for the record, I had a wonderful clerkship with Justice Ginsburg, but I should tell you, I did everything wrong to get the gig, but it worked out. It worked out fine. Thank you. I'm delighted to be back. I have had the honor of doing at least one previous forum here, and so I'm glad to be back. I'm going to talk today about the Supreme Court's ruling last June in Trump against the United States, the immunity case. I'm going to have to talk a little bit of law just to set this into context, but I'm going to try to spend some time talking about what this decision means going forward. Let me start with the conclusion. I think this was a most unfortunate ruling. Whatever the proper scope of presidential immunity might be, this was not the case for an extensive discussion of that subject. The court could simply have rejected the really expansive and unrealistic arguments that Trump made and left other issues for future development if, in fact, we ever see a future case where a president might be subject to criminal liability. Okay, so let's start with a definitional point. What is immunity in the first place? Bottom line, it means that the president can't be indicted, or if the president does get indicted, he could successfully and immediately ask the appropriate court to throw out the case before anything else happens. This is different from other kinds of arguments that criminal defendants might make. Like, for example, if you're a homicide defendant and you want to assert self-defense, which is a recognized defense, you make that argument in the course of the proceedings, and the judge or the jury will ultimately decide whether that defense is well taken. But immunity cuts off the whole process right away, or it prevents the process from even getting started. Now, a little legal background that bears on the question of presidential immunity. There are a few cases that are at least a little bit relevant. One of those cases is the 1982 case called Nixon against Fitzgerald, in which the Supreme Court said that a president is immune from private lawsuits for damages relating to actions taken within the outer perimeter of the president's authority. The court explained that allowing people who don't like what the president has done to sue for damages could distract the president from doing the job. And that was sufficient to say no private damage suits relating to official actions. Now, there's a second case that you all might remember. It's called Clinton against Jones. That's the Paula Jones case. The Supreme Court in Clinton against Jones said that a president could not defer a private lawsuit seeking damages for conduct that is alleged to have happened before the president took office. Clinton wasn't asserting that he was completely immune, only that the case should be delayed until after he left office. The Supreme Court said, no, that's not likely to be the sort of thing that would cause a distraction, so you can't delay the case. The third case is Nixon against the United States. That's the Watergate tapes case, right? Where the Supreme Court said that a president be compelled to disclose legally relevant information for use in a criminal trial. The case did recognize the concept of executive privilege, which in itself is a kind of immunity, right? But it said that privilege was limited. And so Nixon did have to turn over a lot of material that the special prosecutor had sought. Now, one other piece of background that bears on the Trump case. No court has ever addressed the question of whether a sitting president can be indicted. And Trump doesn't address that either. But it has long been assumed that a sitting president cannot be indicted. And the rationale is like the rationale in Nixon against Fitzgerald about civil damage suits. That is, if the president has to, if the president is, a sitting president is indicted, that will be a distraction that will prevent the president from doing the job. The Trump case doesn't deal with a sitting president, although it deals with things that a sitting president did. The indictment came after he left office. Now, the assumption that a sitting president can't be indicted, by the way, explains why Nixon was not, in fact, indicted in the Watergate cover-up case while he was still in office. He was named as an unindicted co-conspirator in the indictment, but not as a defendant. That was a deliberate choice made by the special prosecutor, who didn't want to get bogged down in a side dispute over whether Nixon could be indicted. So the special prosecutor just finessed that. Now, to the Trump case. Special counsel Smith obtained an indictment relating to Trump's efforts to overturn the 2020 election. I think you all know the thrust of the indictment. I won't go through it in much detail here, except as it is necessary to explain what the Supreme Court did. Once the indictment came down, Trump asked both the district court in Washington and the Court of Appeals to throw out the case on the basis of immunity for the president. Both of those motions failed, and so Trump then asked the Supreme Court to take the case. When Trump went to the Supreme Court, he asked the court to address two questions. First, whether a former president is absolutely immune from prosecution for official actions that fall within the outer perimeter of his authority. That language sounds familiar. That's from Nixon against Fitzgerald. Right? The second question that Trump asked the court to address was like in the alternative. If the court wasn't persuaded by his first argument, then Trump said a president is immune from, a former president is immune from prosecution unless he was first impeached by the House and convicted and removed from office by the Senate. And since the Senate did not convict and remove Trump from office, therefore he would be immune on that basis. Now, instead of answering either of those questions, the court reframed the issues in a way that broadened the case. I'll come back to that shortly. Chief Justice Roberts, writing for a 6-3 majority, came down strongly on the side of presidential immunity. The opinion divided presidential conduct into two categories: official conduct and unofficial conduct. Everybody seems to have agreed, including Trump and his lawyers, that unofficial conduct is subject to prosecution. The question is, what about official conduct? Now, repeatedly emphasizing the need for an energetic and vigorous chief executive, Roberts further subdivided the category of official conduct into two categories. One was what Roberts called conclusive and preclusive matters that fall within the core of executive authority, and others that are within the outer perimeter of the president's official responsibilities. Again, that sounds like Nixon against Fitzgerald. Now, the court said, with respect to conclusive and preclusive for executive authority, the president is absolutely immune, right? And so a former president is absolutely immune from prosecution. As for matters within the outer perimeter of official authority, the president is at least presumptively immune from prosecution. And that means that to overcome that presumption, a prosecutor would have to show that taking the case forward would pose no dangers of intrusion on the authority and functions of the executive branch. Now, the court didn't explain what this means, but it sounds like a pretty demanding test that might be hard to satisfy. Now, after laying out this framework, Roberts proceeded to apply it to the charges in the case. Now, with respect to Trump's efforts to strong-arm the Justice Department into investigating sham claims of voter fraud and other irregularities in Georgia and other states, and Trump's threat to remove the acting attorney general who balked at doing these things. The court said this falls within the president's core constitutional authority, and therefore Trump is absolutely immune from prosecution from strong-arming the Justice Department, right? And the rationale is that law enforcement, including investigation and prosecution, that's part of the president's core conclusive and preclusive authority. The president has unquestioned authority to fire the attorney general, and so he has the lesser included authority to strong arm the attorney general. Now, the rest of the case was sent back to the district court in Washington to sort out whether some of those charges fell within official conduct or not, and if so, whether the special prosecutor had rebutted the presumption of immunity. Again, to rebut the presumption, the special counsel would have to show that pursuing those charges would pose no danger of intrusion on the authority and functions of the executive branch. We don't know what that means, but if you just parse the language, that sounds like it could be a pretty demanding test. Now, I said earlier that the court had expanded the scope of the case, and I just want to say that seems like it was a deliberate choice. If you read the majority opinion, Chief Justice Roberts said that we cannot afford to fixate exclusively or even primarily on present exigencies. And during the oral arguments, other justices made similar suggestions. For example, Justice Gorsuch said that the details of the case were secondary because the court was writing an opinion for the ages. And Justice Kavanaugh said that he was less concerned about what he called the here and now of this case than he was with the future. Now, the court ordinarily decides cases on the basis of what's before it and leaves other issues for the future. Indeed, Chief Justice Roberts on more than one occasion has said in print that if it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. So, as I said, this was a case in which the court could simply have said to Trump, your arguments are just completely off the wall. They're wrong, unpersuasive, whatever. You lose, and you're not immune on the basis that you're arguing. We'll let the case go forward and deal with it, deal with other aspects of the scope of presidential immunity down the road. Now, even in its own terms, the opinion is problematic. Chief Justice Roberts repeatedly invoked the first Justice Jackson's, Robert Jackson's, influential concurring opinion in the steel seizure case, in which he talks about the scope of presidential power under various scenarios. If we were in a law school class, we'd talk in more detail about those things. But for now, let's just say that the problem in this case was that Chief Justice Roberts quoted portions of Jackson's opinion. He quoted Jackson in a misleading way that doesn't give you the full context of what Jackson was saying. On 9 different occasions, Roberts referred to this conclusive and preclusive authority statement. That comes from the Jackson opinion. But that's the only part of that sentence that Roberts quoted. The full sentence says, presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution. For what is at stake is the equilibrium established by our constitutional system. You'd never know that the conclusive and preclusive language in Justice Jackson's opinion appeared in a sentence that suggested courts should be really cautious about taking a broad view of presidential authority, particularly when that presidential action conflicts with the expressed or implied will of Congress, where Jackson says presidential authority is at its lowest ebb. And that's where the conclusive and preclusive language comes from. Now, let me just say, this isn't the first time that Chief Justice Roberts has quoted language out of context. In the notorious Shelby County case in 2013, which got at a key provision of the Voting Rights Act, Roberts relied on a theory of equal sovereignty for the states. And he even quoted a 1911 case to that effect. He quoted part of one sentence. He omitted the next sentence that significantly qualified the meaning of the quote that Roberts had used. Now, the whole decision seems to rest on a very formalistic view of presidential authority in particular and the separation of powers in general. Right? If you look at the Constitution divides power, right? Legislative power is primarily in Congress, executive power is in the president, judicial power is in the courts. And a formalistic view basically says that each branch is the master in its own house, and that's particularly true for the president. But if you look at the Constitution, there are all kinds of places in which the branches are interdependent. I mean, for example, the Congress gets to pass laws, but not unilaterally, right? If the Congress passes and the president either signs or vetoes, and if the president vetoes, then Congress can override by a supermajority in both houses. See similar things with respect to, say, appointments. The president nominates, the Senate confirms. Look at the courts, right? The courts get to decide legal cases, but Congress decides on the size of the courts and the jurisdiction of the courts, and even the salaries of the judges. We can play that out longer, but the basic point is that the Constitution sets up a system whereby each branch is primarily responsible for certain things, but nevertheless is checked, has to interact with other branches to prevent the accumulation of too much power in any one place. Now, I could go on like this, but this isn't a law school class, and I want to spend a few minutes at least talking about the implications of this decision. Now, consider the so-called SEAL Team 6 hypothetical, right? That the president arranges or orders the assassination of a political rival or stages a coup. Are those sorts of things immune from prosecution? Well, the court never really engages with that, other than to disparage the examples as just sort of far-fetched and unrealistic. But notice the court never actually says, look, this is ridiculous and unrealistic, and that's not what we're saying, right? They don't even give us that much reassurance. Now, as I read the case, I'm not sure what the answer is. SEAL Team 6, if the president is relying on his authority as the chief law enforcement officer, then maybe the president is absolutely immune. But you got to read the case a little more carefully. After all, SEAL Team 6 is not a law enforcement agency. It's part of the military. The president is commander-in-chief under the Constitution, but the court did not list the commander-in-chief authority as core executive power. So maybe the president is not absolutely immune. Maybe he's only presumptively. That may not be much reassurance, but at least it suggests that there might be limits to how far the immunity would go. I think it's actually a little unfortunate that the SEAL Team 6 hypothetical has gotten so much attention, because I don't think it is an immediate sort of concern. But I do think that the president's authority over law enforcement is a matter of concern, and that's where the court said that the president is absolutely immune. Right? The idea is that because investigation and prosecution are core executive powers, the president has unfettered authority to remove the attorney general, and because he has that power, he has the lesser included power to strong arm the Justice Department to undertake investigations and prosecutions. Now, I think that's not quite a reasonable reading of the Constitution. It might be one thing to say that the president has broad supervisory authority over the Justice Department because it's law enforcement. It's another thing to say that the president gets to micromanage the Justice Department. And that's particularly true in the setting that this case arose. Whatever the scope of the president's power over law enforcement in general, this case is not the general case, right? This was not the ordinary case. Yes, Donald Trump was president in December of 20 and January of 21. But he was also a candidate for re-election. And he had repeatedly made clear that he was not willing to accept the outcome of the election, and he was prepared to try to prevent the certification of the election, right? So Trump had an obvious conflict of interest here. Now, that should give us some pause before endorsing the kind of sweeping claim of immunity that the court accepted, right? Do we really want to give the president unfettered authority to direct the investigation and prosecution of his critics or his political opponents? Now, it might be hard to draw bright lines in this regard about sort of how far is too far, but this case looks pretty easy to me. Let me just leave it at that. Now, the question is, how much encouragement is this going to give future presidents to engage in politically motivated investigations and prosecutions? You know, and that goes directly to what Justice Jackson was talking about in the steel seizure case, where he was talking about the equilibrium established by our constitutional system, a concern that the Trump majority opinion says not one word about. There's also the question of whether the president could be prosecuted for taking a bribe in exchange for issuing a pardon. By the way, the majority opinion says the pardon power is also core to the president's authority, and therefore the president is immune from prosecution relating to granting of pardons. Now, the justices disagreed among themselves. Even some of the justices in the majority disagreed about whether the president could be prosecuted, and if so, what sorts of evidence could be used. Again, this is an exercise, I think, for a law school discussion, not so much for here. My point is that whatever we think about the president's liability for taking a bribe to issue a pardon, it looks like if the president does take the bribe, whether the president is convicted or not of taking the bribe, the pardon will stand. We're Ohioans. Think about HB 6, right, which was passed as part of the biggest political corruption scandal in the state's history. HB 6 is still in the books, right? Even though the House Speaker who was behind the big scandal is now in federal prison. Now, let me come to one other example that I think is more immediate than the SEAL Team 6 cycle, and that's Richard Nixon, right? Remember, after the release of the smoking gun Watergate tape, Nixon resigned. 30 days after he resigned, he accepted a full, free, and absolute pardon from Gerald Ford for all offenses against the United States which he has committed or may have committed or taken part in during his time in office. Now, Nixon would have had no reason to accept the pardon if he were immune from prosecution for actions he took while he was in office, right? And keep in mind, the Supreme Court long before that had made clear that someone who accepts a pardon, at least unless the pardon is based on innocence, which this one was not. The Supreme Court long ago made clear that accepting a pardon is an implicit confession of guilt. Right. Okay. And Nixon could have faced prosecution both for his involvement in the Watergate cover-up and for his role in ordering the burglary of the office of Dr. Lewis Fielding, the psychiatrist who treated Daniel Ellsberg, who you might remember leaked the Pentagon Papers, right? Nixon established a unit called the Plumbers that was supposed to stem leaks from the executive branch, and they're the ones who broke into Dr. Fielding's office. Okay, now, under the Trump decision, it looks like Nixon might have been absolutely immune from prosecution in connection with the Watergate cover-up because he could have made a law enforcement argument, right? He might have been absolutely immune for ordering the break-in of Dr. Fielding's office. And even if he wasn't liable, or even if he wasn't absolutely immune, he would have been presumptively immune, right? So we've got to figure out whether this is absolute immunity or presumptive immunity with a high bar for rebuttal. Now, and that seems to me to raise some important questions about the way the court came at the Trump case, right? And I think it raises two sorts of questions. First, it suggests that our first 44 presidents had reason to fear that they might be criminally prosecuted if they misbehaved in office. Now, maybe this was a small deterrent, but at least it was some deterrent, right? Second, this fear of prosecution doesn't seem to have inhibited presidents both in the distant past and in the more recent past. People who have aggrandized executive power such that people on pretty much both sides of the political spectrum will say has led to the rise of an imperial presidency. We might agree about the importance of an energetic, vigorous, and decisive chief executive without necessarily concluding that therefore the president has to be immune. Now, I will also say, I want to wrap up here because I think I'm running a little bit long, that the court's overreach in the Trump immunity case is unfortunately not unusual. We saw it earlier last term in the case from Colorado about whether Trump could be excluded from the ballot as an insurrectionist, where the court said states can't disqualify candidates for federal office. That was enough to resolve the case, but the majority went further and said, and Congress has to pass legislation before states can do that. Totally unnecessary for the resolution of the case. A couple other more recent examples. Dobbs, the abortion case. Mississippi brought that case to the court not initially to get Roe and Casey overruled, but rather to get the court to change the legal standard to say that the Mississippi regulations were consistent with some kind of constitutional right to abortion. It went further and throughout the right to abortion altogether. And there was a Second Amendment case called Bruin that was decided around the same time, which struck down a New York State firearms law. Now, that law could have been struck down on narrow grounds, but instead the court rejected the entire approach that lower courts had been using in Second Amendment cases, and did so in a way that threatens to unravel a whole lot of other law under the Bill of Rights. So this is not a modest court. Now, let me conclude by saying we might not have faced any of this if the Senate had done its job in Trump's second impeachment trial. If the Senate had convicted and removed Trump from office because of his efforts to overturn the last presidential election, the Senate would have made clear that Trump was disqualified from holding any other office under the United States. And the Supreme Court would never have been in a position to have to decide on the scope of presidential immunity, because I suspect that if Trump had been disqualified from running for office again, that we might not have seen the indictments brought, because the whole point of the effort was to draw a circle and leave Trump on the outside. Okay, let me stop here. I'm happy to take questions.
Okay, you beat me to it. I was just gonna say we should applaud our speaker for his time that you gave up and your expertise on law and the various cases. And Nancy and Gary have some cards, which, you know, they're gonna read this card.
Why can't we pose the question? I don't care if you have not.
Why would you say Ken? Ken.
Okay. May I pose the question?
Ken.
Would you like me to read these? Okay. Please explain peripheral duties of the presidency.
Would you sit?
Please explain peripheral duties of the president, what the president's like.
Can't hear that. Ken, we can't hear front of your mouth.
Peripheral duties.
Okay. I don't think the court describes them as peripheral duties, but I think the distinction is between what the court calls conclusive and preclusive, or that is to say, core executive powers and other powers that the Constitution confers on the president. Now, the two main powers that the court defined as core, that is, powers that Congress can't regulate, are law enforcement and the pardon. Those are the two major examples. As to those, as I said, the court says that the president gets to decide what to do, and Congress doesn't have a role in determining how the president exercises that authority. Everything else that the president does that is, broadly speaking, official conduct, that's like the commander-in-chief power, the appointment power, the power to negotiate treaties, things of that sort. All of those are official, but the president doesn't necessarily enjoy, well, doesn't enjoy absolute immunity. He enjoys presumptive immunity. But again, the key question which the court did not answer is, what does presumptive immunity mean? Or how much of a showing does the prosecutor have to make to rebut the presumption? If the idea is that will pose no danger of intrusion on the functioning of the executive branch, that sounds like a pretty high bar to me. And as a practical matter, the president may well be absolutely immune. Now, if this case survives the election, we may well find out, because I fully expect that any ruling that Judge Chutkan makes in this case, she's the district judge in Washington who's presiding over the Trump January 6th case. Any ruling she makes is almost certain to be appealed. You know that Trump is going to appeal anything adverse, and it's possible that Special Counsel Smith will appeal as well. the court didn't tell us, the Supreme Court didn't tell us what exactly how to analyze the showing that the prosecutor would have to make. Now, obviously, if Trump wins the election, this case is going to go away, and we'll never get an answer. If Trump wins and the case goes away, then we might wonder, how seriously we should take some of the things he's been saying on the campaign trail about going after his opponents. I suppose we could say that one bright side, if there is one, to the Supreme Court ruling is that if Trump wins, it's going to make it a lot harder for him to prosecute Joe Biden. But it isn't going to make it harder for him probably to go after John Kelly or Mark Milley or Liz Cheney, for example, or Adam Schiff, people he has singled out for criticism on the campaign trail.
Ken, we have a question here. Please stand up. Okay, sure. Okay, in the beginning,
Wait, we can't hear you. Can you
Can
put
we-
it on a card? No?
Can you at least can we put you on a mic at least, because there are people watching online?
Thank you.
um,
Here,
Mic
could you come
drop
up here for the mic?
okay. In the beginning of your lecture, you spoke about the outer perimeter, that perhaps a president should be immune because of the outer perimeter of the actions are on the outer perimeter of the functioning of the executive branch. And my question is there any outer perimeter? Okay. Isn't all actions by the executive, doesn't that affect the performance and the view of the president, which affects the performance of his or her duties? And it's like
Okay, let me excuse me, sir. Let me answer your question. And I mean, I don't make the ground rules here, but I think we want to give other folks. I know there are other questions here. All right, so let me try to talk a little bit about this notion of outer perimeter. That language comes from cases that are seeking to impose some kind of legal liability on the president. Nixon against Fitzgerald had to do with whether the president could be sued for damages over something that he did as president. In that instance, it was derailing the career of an Air Force investigator who blew the whistle on massive cost overruns on a military air transport plane. In this case, we're talking about imposing criminal liability. Now, that's different from saying that the president has a totally free hand. And the steel seizure case is a good example of that, right? President Truman, at the height of the Korean War, seized the steel mills because of a threatened strike that he thought would undermine the war effort. The Supreme Court said, you can't do that, right? Your action is not within your constitutional authority. And so the seizure of the steel mills was undone, right? Nobody tried to prosecute Truman for that action, and nobody tried to sue him for damages. And so I think it's important to recognize that the president is subject to legal constraints of some sort. The question that these cases raise when we talk about the outer perimeter of presidential authority is what sorts of legal restraints can be imposed on the president. I think you're concerned that if we take the outer perimeter literally, that the president has an absolutely free hand. I think that's an entirely reasonable sort of concern. But I don't think that's what the Supreme Court has meant when it has used that terminology. Whether the president acted in ways that are consistent with the law in some sense. I mean, Ernest Fitzgerald had other kinds of legal remedies. He just couldn't go after the president himself for damages. And the argument, I think, I have no inside information, but I think if you ask Chief Justice Roberts what he thought the appropriate way to deal with overreach by Trump in connection with the election might have been, I think his answer would have been the Senate should have removed him from office if they thought that it was that bad. Okay, but the Senate didn't do that, and now we are where we are.
We've got a couple of questions here that are similar. One has to do, both of them deal with the Supreme Court. Because one of our audience members said, are they trying to become renegades? And are they an imperial court?
Okay, that's two different questions. And I think I have a slightly different answer to those questions. Renegades, I think, that's not how I would look at it. I think if you ask any member of the Supreme Court, any of the current 9, any of the more than 100 people who have served on the court over the years, they would all tell you, I try to decide every case as it comes without any kind of political agenda. And I think that if you from a purely subjective standpoint, I think that that's right. I think that they tell themselves that, right? And some of them maybe do a better job of this than others, but let's keep in mind that the cases that reach the Supreme Court are, by definition, the most significant cases, the most significant issues in our law. And many of those cases involve genuinely hard questions if you're just thinking in terms of legal doctrine. It's really hard to think that when a justice is facing a really hard question, one as to which reasonably thoughtful and conscientious justices could come to different conclusions. It's hard to believe that a justice's fundamental values and past experience will be completely irrelevant. Because many of the issues have arguments on both sides that are not really, they're not like apples and oranges comparisons, right? You gotta decide at some level. So in that sense, I don't think that we should view the current court as somehow motivated by, or subjectively motivated by an agenda. On the other hand, it's hard to say that the, being on the Supreme Court is not like a talent contest, right? Where there's some test and the 9 top scorers wind up on the bench, or if there's one vacancy, the top scorer at any given moment, right? It's an intensely political process. It has been really pretty much from the beginning. One thing that has changed a lot is that our parties have become increasingly polarized. When I was teaching full time, I used to ask my students in constitutional law, how many Republicans voted for the Affordable Care Act? And the answer everybody kind of knew was 0, right? Then I would say, okay, how many Republicans voted for Medicare? And some of us in this room are probably old enough to remember the debate about Medicare, which was intensely controversial at the time, right? the American Medical Association spent years denouncing socialized medicine and pointed to Medicare as Exhibit A. Well, the answer to the question, how many Republicans voted for Medicare? In the House, a majority, a narrow majority, but a majority. And in the Senate, it was more than 40%. That's inconceivable today, right?
That's when there was a Republican.
Well, okay, now, now,
Right.
now. So when the parties are really polarized, the way that people get on the short list to be appointed is quite different from what it was back when the parties had a lot more overlap. I will tell you, I did not clerk for Justice Ginsburg on the Supreme Court. I clerked for her on the Court of Appeals. As I said, I did everything wrong to get there. But I will tell you that when word got out that President Clinton was thinking about her as a potential Supreme Court nominee, the strongest criticism of the idea came from people on the left, thought that she was insufficiently ideologically pure. Right now, she wound up getting appointed anyway, and she was confirmed by the Senate with only 3 negative votes. But when we have really polarized parties, and where certain issues are very important to people in both parties, you want to find somebody, or there's all this pressure to find people who are 100% committed to the right position on these issues, which is what makes it hard to envision in the near term that we're going to see any justice confirmed to the Supreme Court with more than a handful of votes from the other party, if any. Right. So the process has gotten more polarized in a lot of ways. Now, the second question, I apologize for taking so long on this one, but your second question about, do we have an imperial Supreme Court? Well, let's just say that the current court does not have a modest view of its own role. And the Trump case is a good example, but some of the other decisions that I talked about earlier also reflect that. The court did not have to decide in as broad a way as it decided this case. It did not have to decide the insurrectionist case as broadly as it decided. It did not have to handle the Dobbs case the way it did, although presumably if the court had decided Dobbs on narrower grounds, there would have been another case that squarely presented this should be overruled Roe in cases. Right? Okay, but and I think that is a problem that the court is doing more than it needs to do. And so I think that's a legitimate criticism, even though I have some pretty conservative colleagues who will say, well, you know, the court in earlier times when it was a more liberal majority tended to reach out and decide some things that maybe it didn't need to decide. So in some sense, this gets back to the argument about, you know, what is judicial activism? And the short answer, I guess, is judicial activism is when the court decides something that you don't like. But as I said, I do think that at least some of the current court does have a pretty expansive view of what it should be doing, and I'm not sure that is a good thing. Entirely apart from whether I agree with some of the things that they want to do.
In the newspaper, we talk about,
The mic.
in the news media, we talk about democracy versus authoritarianism. And the question is the Supreme Court, in fact, moving, as you said, the right decisions, but is it moving toward the right authoritarian direction?
I'm not sure how to answer that question. let me back up, and say something about how to situate the Trump immunity decision in a broader framework. There is a theory called the unitary executive. And I think that we can understand the immunity decision in those terms. It's not, by the way, it's not just immunity. The idea that the president has unfettered authority over criminal investigation and law enforcement, that's part of this notion of the unitary executive. The unitary executive theory says that the Constitution vests, quote, the executive power in the president. And people who subscribe to the unitary executive theory say that the executive power means all of the executive power, and that Congress and to some extent the courts need to step back and defer to the president. Now, there are good reasons to think that there are some areas where, for example, Congress should not be intruding too far. And this goes to the idea that the president has the unfettered authority to fire the Attorney General of the United States. There is a line of cases that going back nearly 100 years, and the leading case is about 100 years old now, in which then Chief Justice Taft wrote that the president has the power, the unfettered power to remove any official, any appointed official who exercises any subset of executive power. But that case, remarkably, was about President Wilson's removal of a postmaster in Portland, Oregon. I have written about this case. You don't want to sit here for the rest of the day hearing me go on and rest about it. But what's interesting is that the statute said that the postmaster was appointed for a fixed term of 4 years with the advice and consent of the Senate and could be removed by the president before the end of the 4 years, only with the advice and consent of the Senate. The court said that that statute was unconstitutional. It was, by the way, it was modeled on the Tenure of Office Act, which was the basis for the impeachment of President Andrew Johnson in the 1860s. I think that there's a perfectly good argument that those statutes like that, where the Senate has to agree to the removal of an executive official, that's unconstitutional because it gives Congress too much power over removal. In that postmaster case, the Solicitor General, who was arguing that the statute was unconstitutional, said this is different from a statute in which the law says the president may remove the postmaster before the end of the 4 years only for cause. Right. And Chief Justice Taft skipped right past that. And a few years later, the Supreme Court actually upheld a statute that said that the president has to have cause to remove a member of the Federal Trade Commission before the end of the term. That was a unanimous ruling, by the way. And unitary executive people think that this is an abomination. And don't be surprised, there's a bunch of cases going now in lower courts challenging the constitutionality of agencies like the FTC, the FCC, the SEC, where the statute explicitly or implicitly says the president has to have cause to members of independent agencies before their terms expire. The idea is that the president literally gets to make every single decision. And if it's unrealistic for the president to make every single decision, then the president gets to fire lower level officials who make decisions that he doesn't like. That, by the way, is the whole point behind the so-called Schedule F, where Trump is talking about removing civil service protections from like 40 or 50,000 relatively middle to upper level civil servants. Right, the deep state, right? That's what this is about. And I think it is fair to say that at least some of the current majority of the Supreme Court strongly subscribe to this unitary executive theory, right? Now, are they authoritarians? That's like, well, how do you define obscenity, right? Justice Stewart said, I know it when I see it. But the point is that whatever adjective we apply, the unitary executive theory basically says that the president faces a lot fewer governmental and institutional checks than would be the case if we took a more checks and balances type or functionalist approach to the separation of powers. But as I said, this is not, we're not now talking just about Trump. We're talking about a whole body of thought that has developed over a long period of time.
I'm going to read this next question verbatim. It says, if the Republican judges are so unconcerned with politics and their decisions, why did they all call Roe settled law? And then during their confirmation hearing, and yet today it's.
I can't answer that question. I'm trying to think. I have met 3 of the current Republican justices very briefly. I have never had a really serious conversation. I don't know, but I will tell you that they said that Roe was, quote, settled law or words to that effect during their confirmation hearings. And I mean, let's be honest, confirmation hearings are kind of guerrilla theater. They're not matters of substance. And here, let me just allude to Justice Ginsburg. Her handlers, for better or worse, decided that she should be sold as a sweet, nice grandma, which in fact she was, rather than as one of the most important lawyers in American history, which she also was, because without Ruth Bader Ginsburg, we would not have a law of gender discrimination. Until she started working, the Supreme Court had never in its history struck down a gender-based law as unconstitutional, and it wasn't for lack of opportunity. But the people who were handling her confirmation decided that maybe that wasn't the best look in order to get her through. And so I think that these statements about Roe should be understood as part of this kind of guerrilla theater.
I think.
Okay.
Thank you.
I'm happy to stick around afterwards for a few minutes if people want to talk further.
Okay.
Yeah, microphone.
Our next topic coming up will be, it's titled Post-Election Reality. Let's talk it over. Now, some people call that post-mortem, but that's anyhow. The moderators will be Lori Albright and hopefully John Bacon. They'll be engaging the audience. It's not going to be our normal format, but they will bring up topics and the audience has a chance to respond. If you would like to receive our weekly reminders of forums, please fill out the form, the clipboard card if you haven't already. And you're welcome to our 10:15 service upstairs in the sanctuary. Reverend Partain will be talking on the topic of, quote, Fox woman dreaming. And our music with Mike Carney will cover a broad range from Gregorian chant to James Taylor. So you're welcome to enjoy that. Have a good evening.
Thank you.
Good day.
Excellent, Brennan. Thank you.
So
I will be